Clerk, call the order, please. Honorable Senators, please let us be seated.
Order number 2, procedural motion to hold sittings on Saturday, 19th October 2024. The Senate Majority Leader.
Mr. Speaker, sir, I rise to move this procedural motion, which is for the Senate to hold sittings on Saturday, the 19th of October 2024. That aware that the National Assembly on the 8th of October 2024 resolved with the support of 282 members, being at least two-thirds of all the members of the National Assembly, that pursuant to the provisions of Article 145(2), as read with Article 151(b) and 2 of the Constitution and the Standing Order 65(2) of the National Assembly Standing Orders, His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, be removed from office by impeachment on the ground specified in the motion. Whereas by letter reference NA/DLP/TBO/MTS/2024 025, dated the 8th of October 2024 and received in the office of the Speaker of the Senate on the 9th of October 2024, and on the 9th of October 2024, the Speaker of the National Assembly informed the Speaker of the Senate of the approval of the special motion.
And whereas vide Kenya Gazette number 137/18, volume CXX V1 number 163, dated 9th of October 2024, and Article 145(3)(a) of the Constitution, the Speaker of the Senate appointed Wednesday the 16th of October 2024 and Thursday the 17th of October 2024 as sittings convened for the purpose of hearing the proposed removal from office by impeachment of His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, by plenary. Further, whereas pursuant to Article 145, as read with Article 151(b) and 2 of the Constitution and Standing Orders number 78 and 79 of the Senate Standing Orders, the Senate had the National Assembly on the grounds for the proposed removal from office by way of impeachment of His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya. And further, whereas pursuant to Article 145, as read with Article 151(b) and 2 of the Constitution and Standing Orders number 178, and Standing Order number 78 and 79 of the Senate Standing Orders, the Senate also had the counsel for His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, during cross-examination of the witnesses for the National Assembly on the grounds of the proposed removal from office by impeachment of the Deputy President of the Republic of Kenya. Noting that His Excellency Rigathi Gachagua, the Deputy President of the Republic of Kenya, did not appear during the afternoon sitting of the Senate on Thursday, 17th October 2024, further noting that counsel for His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, sought an adjournment of the Senate until Tuesday, the 22nd of October 2024 at 9 a.m. to allow His Excellency Rigathi Gachagua, the Deputy President of the Republic of Kenya, to appear and give evidence, if any, on grounds for his proposed removal from office by impeachment. Further noting that pursuant to Article 145(4) of the Constitution, a proposed impeachment hearing for the removal from office of a Deputy President must be concluded within 10 days from the date of the reading of the charges, which period in this case expires on Saturday, the 19th of October 2024. Now, therefore, the Senate resolves as follows. 1, to adjourn today's afternoon sitting on Thursday, the 17th of October 2024, and pursuant to Standing Order number 34(4)(c) of the Senate Standing Orders, to hold sittings on Saturday, 19th of October 2024, commencing at 9 a.m. until 1 p.m. and 2:30 until the conclusion of business in the order paper on that day, in order to hear in order to conclude the hearing and determination of the proposed removal from office by impeachment of the Deputy President of the Republic of Kenya. Mr. Speaker, this is a self-explanatory procedural motion that, in light of the request of counsel for the Deputy President, this House adjourns until the closest time possible without violation of the Constitution within which we can sit and conclude on this matter. As I move this motion, though, Mr. Speaker, I must note that the request that came from counsel for the Deputy President, Senior Counsel Paul Mwite, is that we actually sit on Tuesday. I am sure he knows very well the 10-day provision, but I don't know why he wants this House to violate the Constitution, Mr. Speaker, or at least send us into a constitutional crisis. Be that as it may, Mr. Speaker, I want to urge my colleagues that let us sit on that Saturday, despite the fact that I know there are quite a number of Adventists, but duty calls, Mr. Speaker. And this is an important exercise that has the breadth of the country holding still while watching what is happening in the Senate of the Republic of Kenya. Therefore, Mr. Speaker, with those very many remarks, I want to request the minority leader, Senator Justice Stewart Madzayo, to second this motion. I thank you. Justice retired Stewart Madzayo. Sorry, my apologies.
Order, 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 honorable senators. You know, it pays to be attentive. I've just said this is a procedural motion. It does not require notice. Senator Karungo.
Asante Mheshimiwa Spika. Kwanza nataka kuunga mkono hoja hii ya kwamba tuweze pia kupata nafasi ya kuweza kuketi ama kusikiza maoni haya siku ya Jumamosi, kuanzia leo mpaka Jumamosi, kupewa nafasi hiyo. Bwana Spika, tunaelewa ya kwamba hii ni kesi muhimu sana na macho yote katika nchi hivi sasa yanaegezwa katika bunge la Senate. Nataka kumpatia pole sana kupitia kwa wakili ambaye ni senior counsel wetu na ni wakili mkubwa katika Kenya, ndugu yangu Paul Mwite, kwamba yule client wako amekuwa mgonjwa wakati huu. Najua ni ugonjwa ni kitu cha Mwenyezi Mungu. Hatuwezi sisi tukasema ya kwamba mtu hawezi kuwa mgonjwa. Mtu yote anaweza kuwa mgonjwa. Kwa hiyo nataka umpatie pole. Senate imempatia pole na kwamba tunamtakia kila laheri aweze Mwenyezi Mungu kumpatia nafuu, alafu tuweze kumpata hapa. Bwana Spika, tuko katika panda mbili hivi sasa. Ni mgonjwa na tuendelee, ama ni mgonjwa na tusiendelee. Tumpatie nafasi. Kama binadamu naweza kusema kwamba ni nafasi nzuri tuonyeshe binadamu kama maseneta ama nyumba ya Senate kwamba tumpatie nafasi ya yeye akiwa yuko hospitali aweze kuweza kupata nafuu katika matibabu yake. Bwana Spika, mswada huu umekuja wakati mzuri na kwamba tunaweza kumpatia hiyo nafasi. Naunga mkono hoja hii. Asante sana Bwana Spika.
Now, honorable senators, I'll proceed to propose a question, which is that aware that the National Assembly on the 8th of October 2024 resolved with the support of 282 members, being at least 2/3 of all members of the National Assembly, that pursuant to the provisions of Article 145(2) as read with Article 151(b) and 2 of the Constitution and Standing Order 65(2) of the National Assembly Standing Orders, His Excellency Rigathi Gachagua EGH, Deputy President of the Republic of Kenya, be removed from office by impeachment on the grounds specified in the special motion. Whereas by a letter reference NA/DLP/TBO/MTS/2024 into brackets 025 dated the 8th of October 2024 and received in the office of the Speaker of the Senate on the 9th of October 2024, the Speaker of the National Assembly informed the Speaker of the Senate of the approval of the special motion by the National Assembly and further forwarded to the Speaker of the Senate documents in evidence of the proceedings of the National Assembly. And whereas Vide Kenya Gazette number 13178, volume CXX V1, number 163, dated the 9th of October 2024, and Article 145(3)(a) of the Constitution, the Speaker of the Senate appointed Wednesday, the 16th of October 2024, and Thursday, 17th of October 2024, as sittings convened for the purpose of hearing the proposed removal from office by impeachment of His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, in plenary. Further, whereas pursuant to Article 145, as read with Article 151(b) and 2 of the Constitution, and Standing Orders 78 and 79 of the Senate Standing Orders, the Senate heard the National Assembly on the grounds for the proposed removal from office by impeachment of His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya. And further, whereas pursuant to Article 145, as read with Article 151(b) and 2 of the Constitution, and Standing Orders 78 and 79 of the Senate Standing Orders, the Senate also had counsel for His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, during cross-examination of the witnesses for the National Assembly on the grounds for the proposed removal from office by impeachment of the Deputy President of the Republic of Kenya. Noting that His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, did not appear during the afternoon sitting of the Senate on Thursday, the 17th of October 2024. Further, noting that counsel for His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, sought an adjournment of the Senate until Tuesday, the 22nd of October 2024 at 9 a.m. to allow His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, to appear and give evidence, if any, on the grounds for his proposed removal from office by impeachment. Further, noting that pursuant to Article 145(4) of the Constitution, a proposed impeachment hearing for the removal from office of a Deputy President must be concluded within 10 days from the date of the reading of the charges, which period in this case expires on Saturday, the 19th of October 2024. Now, therefore, the Senate resolves the following: to adjourn the afternoon sitting of Thursday, 17th October 2024, and pursuant to Standing Order 34(4)(c) of the Senate Standing Orders, to hold sittings on Saturday, the 19th of October 2024, commencing at 9 a.m. until 1 p.m. and 2:30 p.m. until conclusion of business in the order paper of the day, in order to conclude the hearing and determination of the proposed removal from office by impeachment of the Deputy President of the Republic of Kenya. Now, honorable senators, we have been here before. This is a procedural motion. We rarely debate procedural motions. It's either we agree with it or we don't agree with it. And therefore, with your consensus, I may move to put the question. Very well. I will now proceed to put the question. That aware that the National Assembly on the 8th of October 2024 resolved with the support of 282 members, being at least 2/3 of all members of the National Assembly, that pursuant to the provisions of Article 145(2), as read with Article 151(b) and 2 of the Constitution, and Standing Order 65(2) of the National Assembly Standing Orders, His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, be removed from office by impeachment on the grounds specified in the special motion. Whereas by a letter reference NA/DLP/TBO/MTS/2024 into brackets 025, dated the 8th of October 2024, and received in the office of the Speaker of the Senate on the 9th of October 2024, the Speaker of the National Assembly informed the Speaker of the Senate of the approval of the special motion by the National Assembly, and further forwarded to the Speaker of the Senate documents in evidence of the proceedings of the National Assembly. And whereas Vide Kenya Gazette number 13178, volume CXX V1, number 163, dated the 9th of October 2024, and Article 145(3)(a) of the Constitution, the Speaker of the Senate appointed Wednesday, the 16th of October 2024, and Thursday, 17th of October 2024, as sittings convened for the purpose of hearing the proposed removal from office by impeachment of His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, in plenary. Further, whereas pursuant to Article 145, as read with Article 151B and 2 of the Constitution and Standing Orders 78 and 79 of the Senate Standing Orders, the Senate had the National Assembly on the grounds for the proposed removal from office by impeachment of His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya. And further, whereas pursuant to Article 145, as read with Article 151B and 2 of the Constitution, and Standing Orders 78 and 79 of the Senate Standing Orders, the Senate also had counsel for His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, during cross-examination of the witnesses of the National Assembly on the grounds of the proposed removal from office by impeachment of the Deputy President of the Republic of Kenya. Noting that His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, did not appear during the afternoon sitting of the Senate on Thursday, the 17th of October 2024, further noting that the counsel for His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, sought an adjournment of the Senate until Tuesday, the 22nd of October 2024 at 9 a.m. to allow His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, to appear and give evidence, if any, on the grounds for his proposed removal from office by impeachment. Further, noting that pursuant to Article 145(4) of the Constitution, a proposed impeachment hearing for the removal from office of the Deputy President must be concluded within 10 days from the date of the hearing of reading of the charges, which period in this case expires on Saturday, the 19th of October 2024. Now, therefore, the Senate resolves, 1, to adjourn the afternoon sitting of Thursday, 17th of October 2024, and pursuant to Standing Order 34(4)(c) of the Senate Standing Orders, to hold sittings on Saturday, the 19th of October 2024, commencing at 9 a.m. until 1 p.m. and 2:30 p.m. until conclusion of business in the order paper of the day, in order to conclude the hearing and determination of the proposed removal from office by impeachment of the Deputy President of the Republic of Kenya. Will as many as of that opinion say aye? Aye. Will as many as of the contrary opinion say nay? Nay. The nays have it. Now, honorable senators, the motion having been defeated, we will proceed with the hearing program as had been circulated this afternoon, in which case then we will move to closing statements by the parties. Yes, Senior Counsel Paul Mwite.
Mheshimiwa Speaker, through you, let me recognize the right of this Honorable Senate to decide any issue, any question put to it democratically, which, Mr. Speaker, is what has happened. Arising from that decision of this Honorable Senate, Mr. Speaker, we as the legal team representing the Deputy President are not able to continue appearing without instructions. So we humbly and with a lot of respect take your leave, Mr. Speaker, and the leave of this Honorable House. Thank you.
Now, honorable senators, we shall move to hear the closing statements by counsel for the National Assembly. Clerk, you may now proceed to read the order.
Order number 3, hearing and determination on the proposed removal from office by impeachment of His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya. Counsel for the National Assembly.
You have up to 60 minutes.
Thank you very much,
to
Mr.
make your
Speaker, sir.
closing statement.
On behalf of the National Assembly, we have a total of 4 advocates who would be sharing the time that is allocated to us. Leading the pack, Mr. Speaker, sir, is Senior Counsel Otiende Amolo, to whom I will cede the floor.
Honorable Speaker, honorable senators, I thank you. And this being my maiden appearance on this matter, I sincerely hope I did not drive my learned friend and his team away. But, Honorable Speaker, Kenya is indeed a mature democracy. We are so mature that, Mr. Speaker, we gave ourselves the most modern constitution in recent history 14 years ago. We are so mature that 7 years ago, we had the nullification of the only presidential election.
Honorable Senators. Senator Fernandi, take your seat. Senator Kipsang, may the Counsel for the National Assembly be heard in silence.
Thank you, Mr. Speaker. 7 years ago, we had the nullification of the only presidential election known to history. And today, Mr. Speaker, we are conducting impeachment proceedings unknown to this continent outside of the removal proceedings in a parliamentary system in South Africa. Mr. Speaker, I want to thank you and the Senate for demonstrating the maturity of a democracy. So much so that even when the Deputy President is unable to appear without anything on record, this Honorable Senate has accorded the Deputy Speaker the opportunity, the Deputy President, the opportunity for his counsel to be present, and they have voluntarily exited. The right to appear in person or by counsel is a right under Article 145. But like every other right, you can choose to exercise it or not to exercise it. The idea and the fact of these impeachment proceedings being open as they are and being so democratic, even to vote on the procedural motion, shows how mature our country has become. Mr. Speaker, before the 2010 Constitution, we would not have been here for this process for 2 days. We would not have been taking this process in the National Assembly. The President would sack the Vice President at whims, including for not liking the color of his shoes. The fact that we are here in a situation where to impeach a Deputy President, we have to go through these processes, Mr. Speaker, it shows our maturity. But let it not be mistaken, Mr. Speaker, as some people have, that the process of impeachment is a criminal trial. When you hear people ask the mover of the motion, do you have any proof? Can you demonstrate? It means they are confusing this process with a criminal process. It is not a criminal process. Mr. Speaker, what we have in impeachment is a halfway house between the whim before 2010 and the beyond reasonable doubt proof in a criminal trial. In the words of Article 50, all you have to show is reason to believe. Reason to believe. What the lawyers would call just a prima facie case. You do not have to demonstrate beyond reasonable doubt. So all the questions that I had my learned friends putting to the mover to prove, to demonstrate, they look good to the public gallery. The President and the Deputy, no one asked you to justify why. Because you exercise your discretion. When you lose that confidence, no one should ask you to demonstrate why. That is why it's a political process. Otherwise, it could have been a judicial process or a religious process. Mr. Speaker, it is important to make two distinctions. First, that in this judicial process or a religious process. Mr. Speaker, number one, the beyond reasonable doubt can come later when the other processes come in, like the investigative agencies. Number two, Mr. Speaker, in courts, our courts use an adversarial system where you bring all the documents and you are restricted to what you have brought. The process in this house is inquisitorial under Article 145 all the way to 149. And therefore, it allows this house to go beyond what the mover has brought or beyond what the other witnesses have brought. And this house has exercised that jurisdiction quite maturely. Mr. Speaker, I want to suggest that the idea of impeachment is one which is legal in process only, legal in process, but political in content and merit. As long as all the legal processes for fair hearing are observed, it is not open to anyone to question the merit in terms of the decision of the National Assembly or the Senate, because the safeguard is in the numbers. That is why before you move it in the National Assembly, you need 117 members. For it to pass, you need at least 2/3. Even in this House, you need 2/3. That is the safeguard. The safeguard is not in the legal technicalities. Mr. Speaker, for that reason, while it looks juicy and it looks very good to the gallery to have that intense cross-examination such as we saw of the mover of the motion, Mr. Speaker, it is irrelevant. It is highly irrelevant, and to the untrained eye, they might think you are achieving much, but you are not achieving much. It must be remembered that the impeachment here is of the Deputy President, not the mover of the motion. So however much you discredit the mover of the motion, you do your client no justice when you do not address the substance of what is moved. Mr. Speaker, allow me to refocus on Article 150. Article 150 makes a very important distinction. And I heard the lawyers of the Deputy President saying that, there's precedent. There is no precedent in our court in terms of impeachment. There is precedent in terms of removal from office of governors under Article 181. The word used is removal. The word impeachment does not appear in Article 181. But when you come to Article 150, two words are used. You can remove the Deputy President first, Mr. Speaker, under 151A, under 151 is removal. To that extent, the question of removal in 151, you can use the same standards in Article 181. But B, it says, or on impeachment. There is no other provision for impeachment, and we have not undertaken impeachment in this country. For that reason, Mr. Speaker, while the wording might look similar, the principles are different. Because for removal, for example, under 151, it's a strict legal process. You have to show and demonstrate that the Deputy President has physical or mental incapacity. But when it comes to impeachment, it's a different matter. It's more of a political matter. Mr. Speaker, impeachment is a demonstration of impropriety, of unfitness for office.
In absentia, even in normal criminal courts, if you are to go to Kibera or to Milimani or to Makandara, there is no possibility that a court of law can proceed in the absence of an accused person because of the right to a fair trial and the right to be heard.
Wakili, there are plans perhaps to have a new Deputy President be sworn in tomorrow or on Saturday. Are you seeking to block this from happening?
We believe that we live in a proper constitutional dispensation where the Constitution has spelled out what should and should not happen. So we shall continue.
Translate to about 42 million out of the 50 million Kenyans. That is a significant number. Mr. Speaker, if this House is equally to vote, you translate it to the equivalent number of people it's representing. It is not a heavy matter. If it was any less, it would have been a decision for a single judge. Mr. Speaker, allow me to address two things, then I sit, in terms of substance. One, you have 11 charges. 4 of those charges oscillate around one issue, and that is the utterances by the Deputy President. And the charge is he made insightful and discriminatory utterances to the effect that only those who voted for the Kenya Kwanza are entitled to resources and positions in government in Kenya. That is the summary of that charge. That charge is contained in ground 1, ground 5, ground 6, and ground 10. I want to submit, Mr. Speaker, that if you find even only that one charge to have been satisfied, then I want to implore the senators to vote yes for all those 4 grounds together. Has it been satisfied? Mr. Speaker, those utterances are admitted by the Deputy President in the documents before you. The meanings of those words in their variety is known to you and is known to Kenyans. The danger in words is something we know in this country way back in 2007. In our neighboring country, Rwanda, we know what words did. I heard the lawyers of the deputy president suggest that he did not take any action. Under the law, under Article 10, under Article 27, you do not have to take any action. Utterances are enough, because utterances can do the very damage that the Constitution intends not to be done. Mr. Speaker, what is his response to that charge? There are two. The first one is he was exercising free speech. Mr. Speaker, that is the easiest to dismiss. I invite the senators to look at Article 33, 2D, Roman 2. It is express, and it says, freedom of expression cannot include advocacy for discrimination, and that's what he was doing. What's the second defense? That whatever he was saying is contained in the various coalition agreements under the Kenya Kwanza coalition that were filed and signed before election. Mr. Speaker, with tremendous respect, allow me to remind the Deputy President that this is the Republic of Kenya, not the Republic of Kenya Kwanza. Mr. Speaker, for that reason, you cannot elevate agreements under the Kenya Kwanza coalition above the legislation of this country, above the constitution of this country. Section 13 of the NCIC Act is very clear that those utterances are unlawful, in fact criminal. Article 10 and Article 27 of the Constitution are equally clear that you cannot make such utterances. So to come and say that I uttered them because they are contained in a coalition for one particular political coalition is in fact an admission. It is an admission of violation of the Constitution. And Mr. Speaker, if members wanted one clear admission of guilt, it is this one. It is not denied, the justification cannot stand, and indeed, Mr. Speaker, once one of the senators asked for the justification, and I heard the lawyers refer to the Schedule 3 of the Political Parties Act. Mr. Speaker, I invite the senators to look at Schedule 3, Clause 3E. It is very specific. It talks of sharing positions in the coalition structure, not sharing positions in government. And to try and mislead this august House makes it an aggravation of a wrong. And I invite you, Mr. Speaker, to find that there was a breach of this. And I think the worst of all is we were able to play a clip of the Deputy President after showing what he had uttered, saying that he has no apology. He said he has no apology. The clip was played here. I invite you to look at the 798 pages that he has filed. There is nowhere where he has rendered an apology. So he leaves you in a position where he says, even if he was not impeached, he will continue doing that because in his view, it is justified by the Kenya Kwanza coalition. Mr. Speaker, I invite the honorable senators to find that this ground has been proved and to impeach the Deputy President on ground 1, ground 5, ground 6, and ground 10 for breach of the NCIC Act, Section 13, and breach of Article 10 and 27 of the Constitution. My last point, Mr. Speaker, allegations of corruption. Mr. Speaker, this House has had the various allegations of corruption. You had the very direct evidence of Dr. Mulwa in terms of KEMSA. You had the very direct evidence of the Deputy CEO of ESCC. You had the various evidence in terms of Olive Garden, Vipingo, Outspan, and many others. But I will not go there. I will let you assess that, and my colleagues will address that. I want to address one fundamental thing. In your bundle, honorable senators, in volume 2A of the exhibits, you will find reference to a particular court decision. This is the decision on page 60 of 123. That is the decision
in asset recovery agencies versus Rigathi Gachagua. This decision was referred to, but I just want to take you directly to the finding on page 77. This was a case that the Asset Recovery Agency filed against the Deputy President. And this case was actually finalized 10 days before the last general election. What did the court find? The court found positively and declared that Rigathi Gachagua was found to have been having funds which were proceeds of crime and therefore liable for forfeiture to the state to the extent of 200 million. Mr. Speaker, it is important to note that in the 798 pages of the documents filed by the Deputy President,
there is not a single document that shows that this judgment has been set aside, has been compromised or revoked. In an inquisitorial system, you do not need to restrict yourself. Where there's a judgment produced that shows that you have been found guilty of having proceeds of crime, the expectation would be that you produce a document negating it. The fact that no document has been produced, I invite you to invoke an adverse inference that either there is no such document, or if there is, it does not deal with that finding. Mr. Speaker, I want to submit that there is good reason why that document was not produced. Why would you produce? Mr. Speaker, I want to suggest that had it been produced, we would then have demonstrated that that document is unlawful. Because in law, and I submit respectfully, once you have been found guilty of what amounts to a criminal offense, you cannot then subsequently compromise it.
Because this is not a civil claim. A crime is a crime against the state. It is not personal to the Asset Recovery Agency. And therefore, those findings can only be set aside by positive findings of a superior court, and there's none. So the record shows that Rigathi Gachagua was convicted of corruption. And what that means, Mr. Speaker, that not only was he convicted, but even to come here and allege that he was convicted and thereafter, they entered some sort of negotiation, is in itself evidence of abuse of power. Because he was convicted 10 days before election, shortly thereafter, it is alleged they compromised it in what would be an illegality. Mr. Speaker, on that account, ground 7 of the charge must succeed. Respectfully, Mr. Speaker, honorable senators, I plead with you to find the Deputy President guilty of the grounds as charged. Thank you very much. Allow me now to introduce the Honorable George Murugara to take over.
Thank you very much, Mr. Speaker and honorable senators. My name is George Gitonga Murugara, Member of Parliament, National Assembly, and the Chairperson of Justice and Legal Affairs, and I'm here to represent the National Assembly with my colleagues. Honorable Speaker and senators, I'll deal with only one point which supports ground number 11.
Part of the Deputy President were actually committed when he was not the Deputy President, and therefore do not apply to the proceedings before this House. Reference is made to Article 151B of the Constitution, which provides that the ground for impeachment would only be serious consideration of serious reasons to believe that an offense has been committed. There is no time limit that is set, because once there are reasons to believe that an offense has been committed, then that stretches back to whatever time that offense would have been committed.
This is to say, if in the pendency of the life of the presidency or the deputy president, it is discovered that before you assumed the office, you committed an offense that forms a ground for impeachment. This leads me to the next argument, which are the admissions that the deputy president actually made before the House. Clearly, he admitted that the issue of shareholding in Kenya was live and he was part and parcel of it. Therefore, Kenyans were shareholders. He actually admitted in the House and also in the press in the country that he believed the president was behind this motion. He also admitted that he had actually gone against the principle of collective responsibility on the basis that the cabinet had made unconstitutional decisions, which decisions he had to disobey. He also went on to dismiss this parliament as a theater of the absurd, and that he did not expect much from here. The question is this, and that, honorable senators, you have to grapple with. If the deputy president was actually to be saved by this House, with whom would he work? He would not work with the Kenyans whom he has antagonized with his shareholding notion that he has spread across the country. Number two, he would have difficulty serving with his boss whom he has accused of being behind this motion. He would not actually work with the cabinet where he is responsible for everything that is done in the cabinet and the sub-cabinet committees brought together by the principle of collective responsibility. He would not be able to work with this parliament, which he has called a theater of the absurd. With whom would he work? This is the question you have to ask yourselves. What we have before us today is like a marriage. And I have to draw that analogy because actually the position occupied by the subject of the discussion and the motion, the Honorable Rigathi Gachagua, is now untenable. He cannot hold that position because his position is irretrievable. He cannot work with any of the organs and bodies he's supposed to work with. Therefore, the position being irretrievable, then it means actually he has to be impeached. And I implore upon you to actually do so. Where a marriage is irretrievably broken, you cannot apply any law. The marriage is gone. Whichever law you try to apply, it does not matter. For the deputy president today, we cannot apply any measure of legalese because this is not likely to assist us in any way. The position remains, this is a political process, these political offices they are holding, and therefore they are irretrievably broken. As I pen off, honorable senators, honorable speaker, sir, I'll refer you to a biblical book in the Old Testament, the book of Jonah, chapter 1. And when the senators retire, they can actually look at that, the entire chapter. What happened here when Jonah disobeyed the command from his superior, and that was the deity? He actually had to flee. And when he fled, he took a ship to a different city, not where he had been commanded to go. What remained was, on the journey, the waters were faced with tempest, and eventually the tempest had to be calmed by tossing Jonah out of the ship. The ship here is actually the presidency. The ocean is actually Kenya. Jonah is the insubordinate deputy president who actually cannot work with the entire government and the country, and whose position today, as he holds, is untenable. With those remarks, I urge you, honorable senators, to actually uphold this motion, and to the best of my belief and conviction, Not only ground 11, which I have submitted, the rest of the grounds have been approved. Thank you very much. 2 minutes to Honorable Zamzam, who is also going to make a statement and a submission. Thank you very much.
Mheshimiwa Spika, kama mwakilishi wa bunge wa eneo bunge la Mombasa na bunge la taifa la Kenya, Mheshimiwa Spika, leo nimekuja hapa kuwaletea yale mashtaka ambayo yameonekana katika bunge letu. Mheshimiwa Spika, Mheshimiwa Spika, mengi yamezungumzwa. Mimi si mwanasheria, lakini mimi nazungumza kama yule Mkenya ambaye yuko pale chini, hajui sheria, hajui nini, anaomba amani katika taifa. Mheshimiwa Spika, Mheshimiwa Spika, video zimechezwa katika bunge hili. Tumeona Mheshimiwa Naibu wa Rais akijipiga kifua, hasa kule Taita Taveta. Nimeona Mheshimiwa Spika akiwaambia kuwa hawana shares, na akawaambia nyinyi kama mnataka hisa mungoje 2027, manake hata rais akinambia mimi niweze kuwaletea maendeleo, namwambia kwanza subiri niangalie kwenye mfuko wangu wakiwa kama wako kwenye orodha ya kupewa maendeleo. Mheshimiwa Spika, Mheshimiwa Spika, ifahamike kuna wakati mmoja Kenya iliingia kwenye vita sana. Mheshimiwa Spika, tuliona maiti ya kina mama, mtoto hajui mama amekufa, mtoto alikuwa ananyonya matiti. Mheshimiwa Spika, Mheshimiwa Spika, hatuwezi kutaka taifa hili lirudi kule tena. Mheshimiwa Spika, Mheshimiwa Spika, ndani ya Mombasa nina wajane ambao wananitegemea sana. Mheshimiwa Spika, huniletea malilio yao, na leo mimi kama mama kaunti wa Mombasa nalia kwa sababu ya mayatima ambao waliachwa na ndugu ya naibu wa rais. Mheshimiwa Spika, haiwezekani kuwa leo mimi na mume wangu tutafute mali yetu na tuna watoto wetu, kisha akifa ende mbele ya Mwenyezi Mungu nije nipokonywe mali yangu niache na watoto wangu wakihangaika. Mheshimiwa Spika, ukiangalia umri ya hawa watoto wa ndugu yake Mheshimiwa Naibu wa Rais wametoshea kupewa urithi wao. Mheshimiwa Spika, lakini hata kuna tetesi mwingine yoozea kule kwa jela. Mheshimiwa Spika, kwa hiyo Mheshimiwa Spika, mimi nasema, nilisikia mwanasheria akisema to save makanga. Mimi nasema makanga ameiba pesa ya abiria, dereva hana pesa ya kupelekea mwenye gari. Kwa hiyo mimi nasema wamwache dereva apeleke abiria mpaka station ya mwisho, kisha akifika kule atajua atatafuta makanga mwingine namna gani. Mheshimiwa Spika, hatuna sisi uchungu na watu wa mlima, lakini tunachosema tulikuwa na Uhuru, tulikuwa na Kibaki, tulikuwa na Kenyatta, hatukuwahi kuona mambo ambayo tumeona kwa Deputy President. Mheshimiwa Spika, huyu ni sumu, atavuruga Kenya, ataharibu Kenya. Naomba bunge hili la Seneti, amani ya Kenya iko kwenye mikono yenu, na waomba mtoe uamuzi wa uhakika. Huyu jamaa hapendezi kabisa kuwa katika nafasi ambayo yuko ndani sasa, na waomba kwa heshima na taadhima tuweze kumtimua leo, Kenya iweze kupata mtu ambaye atamsaidia rais kufanya kazi akiwa ameweka amani na umoja wa Kenya mbele. Asante sana Mheshimiwa Spika.
Mr. Speaker, sir, very briefly, I will wrap up the submissions on the part of the National Assembly. I'll endeavor not to repeat what has already been captured on the record. Mr. Speaker, sir, I've agonized and reflected on the place of impeachment proceedings, not just in our country, but across the world and across other democracies. Mr. Speaker, sir, I've had occasion to look at the history, particularly of the United States of America, from the days of Andrew Johnson in 1868, Richard Nixon in 1974, Bill Clinton 1998, and Donald Trump 2019. Mr. Speaker, sir, I asked myself, what does impeachment proceedings seek to serve in a democracy? In my reflections, one of the clear conclusions is that it is a check and a balance through which the populace can then hold their leaders accountable. It is an avenue through which the populace can ask their leaders whether they're doing that which is in keeping with the social contract or the understanding that they had at the point of election or delegating their direct powers to those elected leaders. So in the context of Kenya, where then do we find impeachment? Mr. Speaker, sir, our history has taught us very bitter lessons. We remember the events that bedeviled our country after the 2007 elections. It is after those events that we gave ourselves a new constitution. In that new constitution, Mr. Speaker, sir, we found it necessary to, in an unprecedented way, speak about our values, speak about the fabric of our society, the things that pull us together, the things that we share as a people. The preamble to our constitution, in particular, paragraph 3, reads, "We, the people of Kenya, proud of our ethnic, cultural, religious diversity, and determined to live in peace and unity as one indivisible sovereign nation," and continues so on and so forth. From those words, we realize what the thinking of the Kenyan people was right from page 1 of framing of our constitution. We then went to substantive provisions. A lot has been said about Article 10 of our constitution, to the extent that it speaks to the values that as a people we want to be associated with. We have dedicated a whole chapter of our constitution to the questions around leadership and integrity. It then tells us how central the values that we hold are to each other as a nation. Now, if we look at impeachment from that lens, then we realize and appreciate that impeachment then comes in to hold our leaders at an even higher pedestal, so that we have a tone at the top that is acceptable, a tone that gives us what has been called elsewhere political hygiene. We have had occasion in this country where people who have been in positions of leadership have been treated in what other people have thought has been harsh treatments. But it is because when there's a tone at the leadership to be set, it must be clear, it must be vibrant, and it must be the right tone. We've had leadership, people from the leadership who've lost their office because of having pinched somebody. We have people who have lost their offices because of utterances that were considered inappropriate. A slap has gotten somebody to go through a fairly painful process. It is because the slap is not necessarily the issue, it is the message that it sends. And so similarly, when we talk about our leaders, we then must ask ourselves, what does one wrong word do to the fabric of our society? It is on the basis of that background that we then consider the impeachment motion that is currently before this House. My colleagues who have spoken before me have taken us through the provisions of Article 150, 1B, which then speaks to the very grounds that this House should consider in whether to impeach His Excellency, the Deputy President, or not. I wouldn't want to go into those grounds because the record before this House contains material in support of those grounds. I would urge, Mr. Speaker, sir, that now that His Excellency, the Deputy President, has had occasion to present material before this House, that this House could consider in response to the motion for impeachment. When you retire to debate, to deliberate, we urge that you take into consideration the entirety of that material. We also ask that you also take time to look at what the mover of the motion presented before this House, as well as all the witnesses, including what came from public participation. That would give us an opportunity to, in a very objective way, reflect on what and how to deal with the questions that have been presented. I need not go into the specifics of each of the charges, but if I was to give examples, when we have a leader occupying the high office of the deputy president of this country, somebody who is required by the Constitution to take an oath confirming or affirming to Kenyans that they will not divulge whatever comes out of secrecy, out of confidential conversations that come to their knowledge by virtue of the office that they occupy. If that person then defies that bond or that commitment that they've had with Kenyans, it is a gross violation. Similarly, when we have somebody occupying the space of the high calling of the office of the deputy president, admitting issues that would amount to conflict of interest between his personal interest, his family interest, and which have financial implications. Again, our laws then dictate that those are reasons that would would be sufficient to impeach such a deputy president. We've had examples that have been given about utterances that have been considered to be unpalatable. Again, looking at the entire framework of what our Constitution anticipates, looking at what those words would mean to a man off the streets of Nairobi, off the streets of Mombasa, or any other place. If we all come to the understanding that those words taken in their natural meaning could cause some measure of discomfort, they are considered to be divisive, they are considered to be of such a nature as to bring or sow seeds of discord between us as people in this country, then it is the responsibility of this House to speak, and to speak on behalf of the people of Kenya, because it is one way of ensuring that there are checks and balances that flow from the constitutional powers vested in this House. Mr. Speaker, sir, as has been demonstrated through the many tons of documents that have been availed before this House, the cross-examination that has attended to the witnesses that have been before this House, and the material that has been placed by the mover, by all the parties who've had an opportunity to participate in the proceedings of this House, we have absolutely no doubt that this House is perfectly capable of making the appropriate decision in each and every of those counts. And just for emphasis, Article 150, Subarticle 1B gives us 3 grounds. We do not have to have beyond 1. Any one of those is more than sufficient to make the call or to pull the trigger on an impeachment motion. Mr. Speaker, with that, I rest, and we thank you for according us this opportunity this evening. Most obliged.
So, are you done now with your submissions?
Yes, Mr. Speaker, sir. We are done.
Thank you. Now, honorable senators, I'll refer you to the program. You will notice that after the closing statements from the parties, the Senate is supposed to move to a closed session to deliberate on the issues that have been raised, and that is pursuant to our rules of procedure. That is demanded of us by the rules of procedure. So at this juncture, I will allow the parties to retire as the Senate moves to a closed session. That closed session will take us not more than half an hour. After that, we'll come back. Once we are back, there's going to be a special motion contained in an order paper. That is the motion that will allow debate culminating into honorable senators getting the opportunity to cast their vote on each of those charges, of the 11 charges. So Counsel for the National Assembly, you may now retire. Once we resume open session, of course, you resume your seats.
Thank you very much, Mr. Speaker, sir.
The media and live broadcasts has to cease forthwith.
Na mtazamaji, ni hoja ambayo inaendelea kujadiliwa bungeni sana wakati kama huu ambapo ni dakika 20 baada ya saa moja. Kumbuka ni baada ya mdahalo mzima wa iwapo maseneta wataendelea kujadili hoja hizi za kubanduliwa kwake naibu rais Rigathi Gachagua. Mgonjwa anaugua na amekimbizwa hospitalini katika hospitali ya Karen, lakini baada ya kupiga kura kwa sauti, maseneta wamekubaliana kwamba wataendelea kujadili hoja hizo, kuzipiga msasa, kuzitathmini tena baadaye wapige kura baadaye usiku wa leo. Na tumemwona Spika wa Seneti Amason Jeffa Kingi akitoa mwelekeo wa pumziko fupi, tena baadaye watakuwa narejea na kuendelea na hoja hizo kujadiliwa tena baadaye wapige kura. Kitu ambacho tumeshuhudia ni kwamba waliosalia katika ukumbi huu wa Seneti ni mawakili wa bunge. Tumemwona Chindo Molo pale akitoa hoja zake. Eric Gumbo pia alikuwa mmoja ambao alitoa hoja, wakiwa hawa ni mawakili wa bunge ambao wanaunga mkono hoja ambazo ziliwasilishwa na mbunge Mwingi Mutuse bungeni, zikiwa na makosa matatu makuu na vipengee 11, vipengee ambavyo wanasema kwamba vina uzito kupita kiasi, kwamba Gachagua hatapona na watafanya vyovyote wampigie kura ili iweze kung'atuka. Lakini pia tumeona baadhi ya maseneta ambao ni wenye kuegemea mrengo na upande wa naibu rais Rigathi Gachagua wakiondoka katika Seneti, mawakili wake pia wakiongozwa na Elisha Ngoya, Ndegwa Njiru pamoja na Tom Macharia. Pia tumemwona Swaya Ogeto na John Njomo wakiondoka katika majengo yale na ukumbi wa Seneti, kuonyesha kwamba hawako tayari kuendelea kusikiliza, maana ombi lao lilikuwa ni kwamba apatiwe siku kadhaa ili waweze kumleta siku ya Jumanne wiki kesho. Lakini kipengee ambacho kimeleta kivangaito na mdahalo mpana zaidi ni kipengee cha 145 ambacho kinatoa hoja na mchakato mzima wa kuweza kubanduliwa kwa rais, ambapo vile vile kinaleta mwavuli ule pia wa naibu rais namna gani anaweza kubanduliwa na Seneti kupitia kikao maalum, kamati maalum ya maseneta 11 ama kikao kizima cha Seneti kama tulivyoshuhudia. Na mwishowe ni kwamba inavyozungumzia pale sehemu ya 5 ibara ile ya kwanza ya pili kuelezea namna gani anafaa kufika anayeshtumiwa na makosa akiwa ni naibu rais wakati huu afike na pia aweze kuwakilishwa. Lakini maseneta wamepiga mchakato wa kipengele kile na kuona kwamba ana haki ya kuweza kufika na ana haki ya kuweza kuwakilishwa, na kwamba haki ni kitu ambacho mtu anapewa, akipenda atachukua, asipopenda atakiacha. Ndio maana wameamua kwamba wataufanya mchakato huu uishe leo na waweze kupiga kura. Karibu mtazamaji, ni matangazo ya Kiswahili kutoka sasa hadi watakaporudi maseneta, na tutaendelea nao hadi mwendo wa saa 2 kabla ya kuangalia kura itapigwa namna gani. Matangazo haya kwa lugha ya Kiswahili. Mimi naitwa Lofty Matambo Makinika, tutakuwa na uchambuzi hapa na pale, lakini zaidi pia kuletea na kukudondolea dondoo za hapa na pale zilivyokuwa mchana kutwa kutoka
majengo haya ya Seneti. Kumbuka mtazamaji, pia tumekuwa na maripota wetu katika maeneo mbalimbali ambao wamefika, wengine katika hospitali ile ya Karen, na tumemwona mwanahabari wetu Brian Mushiri ambaye ametueleza kwamba alipofika katika hospitali ya Karen amejuzwa kwamba kwa kweli waliofika pale ama waliokuwa pale wameshuhudia na kuona kwamba naibu rais Rigathi Gachagua amefikishwa pale akiwa mgonjwa, lakini hakuwa na mengi ya kuweza kutathmini na kueleza ulikuwa ni ugonjwa aina gani, tofauti na ama kama alivyozungumza wakili wake Paul Mwite kwamba ana maumivu ya kifua, swala ambalo pia tumemwona James Orengo ambaye ni kiongozi wa wale mawakili wa bunge akisema kwamba alivyomuona jana, alivyomuona leo akiingia, manake leo tumemwona pia akiingia na mwanawe pale asubuhi, ni kwamba alikuwa mzima, mwenye siha na jaha yake, na alisema kwamba inaajabia pia kuona namna gani baada ya muda wa saa moja kuchukua pumziko la chamcha naibu rais Rigathi Gachagua amekuwa mgonjwa. Na mtazamaji, kama nilivyokugusieni ni kwamba naibu rais anakabiliwa na makosa vipengee 11, yale makosa matatu. Kosa la kwanza likiwa ni kuvunja katiba sehemu ya 10 ibara ya pili a, na vile vile sehemu ya 27 ibara ya 4, sehemu ya 73 ibara ya kwanza a, ambalo ni kosa la kuvunja katiba kwa kiwango kikubwa. Na mtazamaji, vile vile kuna makosa mengine. Kosa lake la pili likiwa ni kosa, nitakuwa na kuonyesha, litakuwa ni kosa lile la kipengee kosa la kuweza kukosa kumheshimu rais ambaye ni mkubwa wake, na ni kwa nini hakuwa anafuatilia sera zile ambazo zinajadiliwa. Kwa mfano katika baraza la mawaziri, vinginevyo alikuwa anajitosa ulingoni na kwenda kueleza sera na kanuni mbalimbali. Kwa mfano kama sera za kufurusha watu ambao wamekaa wamefanya majengo yao kando na mito, na ni kwa nini shughuli kama hizi, matamshi kama haya yalikuwa yanakiuka na kwenda kinyume na katiba ya Kenya. Kumbuka mtazamaji, mchakato huu mzima ambao unafuata na kipengee cha 145, vile vile kuna baadhi ya mdahalo ambao umejikita katika kipengee cha katiba 150 cha ni namna gani naibu rais alivunja sheria na anafaa kubanduliwa liwe liwalo. Mawakili James Orengo kama nilivyokutajia, Otiende Amollo wakiwa wanaongoza upande wa bunge, na vile vile wakili Ndegwa Njiru akiwa ndiye anaongoza upande wake wa kuweza kumtetea, akiongozwa vile vile pia na Elisha Ngoya, na Paul Mwite akiwa ndiye anayeongoza. Mtazamaji, mchakato huu ulioanza wiki jana tulishuhudia pale bungeni wa bunge 283 wakipiga kura ya kuweza kusema kwamba abanduliwe naibu rais Rigathi Gachagua kwa sababu hafai kulingana nao na makosa yote 11, japo aliyakana hata hapo jana. Ni makosa ambayo sasa hivi tutakuwa tunatarajia na kuona ni namna gani atakuwa ni mwenye kupigiwa kura na kuweza kung'atuliwa mamlakani, ama atakuwa anapona kwa mujibu wa maseneta watakavyokuwa wanachukua hatua za kumpigia kura. Na mtazamaji, ameshuhudiwa mengi bungeni. Hebu tuangalie hii leo katika bunge la Seneti kumekuwa na kipi cha kuweza kudondoa. Mtazamaji, bunge la Seneti limefutilia mbali ombi la mawakili wa naibu rais Rigathi Gachagua kuwa ni mgonjwa na kuomba muda zaidi ili apate nafuu. Spika wa bunge Amason Kingi amewapa maseneta uhuru wa kuendelea kutoa mawasiliano yao ya mwisho kuhusu mchakato wa kumwondoa afisini naibu rais Rigathi Gachagua.
As this process is time-bound by the Constitution to be concluded in not more than 10 days, pursuant to Article 145 as read together with Article 150 of the Constitution, and noting that the period provided for ends on Saturday the 19th of October 2024, the only window open to the Senate, if it so oblige the request for adjournment sought by counsel for the Deputy President, will be to gazette Saturday the 19th of October 2024 as a further and final day for hearing of this matter. Now, honorable senators, ladies and gentlemen, such a request is not made to the Speaker, but to the Senate, and is accordingly a matter for the Senate to determine. To facilitate this decision, I direct the Clerk of the Senate to circulate a supplementary order paper incorporating a notice of motion and a motion for adjournment sought. This being a procedural matter, the motion, if carried, will result in the Speaker gazetting Saturday the 19th of October 2024 as a sitting day to conclude the hearing and determination of this matter.
Na mtazamaji, kabla hapo Spika wa Seneti Amason Jeffa Kingi alikuwa na muda mgumu kuwatuliza maseneta ambao walikuwa wamepandwa na mori kuuliza ni kwa nini muda wao unayoyoma, ilhali Naibu Rais Rigathi Gachagua hajafika Seneti kuhojiwa, kujitetea ili kupigiwa kura. Hivi ndivyo mambo yalivyokuwa.
Speaker of the Senate on
Alhamisi tarehe 17 Oktoba saa 8:30 mchana, maseneta walirejea ukumbini baada ya chamcha
zao wamezikabidhi mikononi mwetu.
Ratiba ya mwongozo wa Seneti ikiwa wazi kumpa fursa Naibu Rais Rigathi Gachagua muda wa saa 2 hivi kujitetea kabla ya kuulizwa maswali na mwanasheria James Orengo anayeliwakilisha bunge la taifa, kisha baadaye maseneta wapige kura
kwa njia ya haki na uaminifu.
Lakini sekunde na dakika zilifutika. Aliyetarajiwa kusimama kizimbani kujitetea Rigathi Gachagua asionekane. Taharuki kaanza kutanda Seneti, na ni hapa ambapo mdahalo wa iwapo kiapo cha gavana wa Nairobi Johnson Sakaja kinafaa kutumika au la ulizuka.
They did come with a bundle of documents from the National Assembly, or it was filed after the Senate was seized of those documents.
Mheshimiwa Speaker, I have been corrected by my colleagues. The affidavits where the affidavit by Governor Johnson Sakaja was actually part of the public participation. So it was part of the record.
Na baada ya spika kutoa msimamo wake, mawakili wa Gachagua walikuwa na kibarua cha kumwasilisha mteja wao.
To let you know that the clock is running and it's running on your client.
During that period that I went to try to find out why he wasn't here, the sad reality is that the Deputy President of the Republic of Kenya has been taken sick, very sick, and as I address Mr. Speaker in this honorable House, Senators, he is in the hospital, Mheshimiwa Speaker. That is a sad reality.
Hapa maseneta walianza kuishiwa na subra na kumpa spika muda mgumu.
Unprecedented. You have not done this and we are seated in the chamber. The mess is in place. We have no idea how long we are going to wait.
Order! Order, honorable senators. Order. The floor is available to the Deputy President and no other senator or no other element.
Ilibidi Seneti kuchukua break ya ghafla ya muda wa saa 1:30 hivi hadi saa 11 jioni. Kisha wakili wa Gachagua Paul Mwite akafika na ujumbe.
On the advice of his doctors, he said he must have complete rest for the time being. I was, however, informed by his doctors that he is currently suffering intense chest pains.
Waliokuwa wakifuatilia studioni na runingani pia wakiwa na mshawasho wa kujua kitakachojiri. Kipengele cha 145 cha katiba kinachotoa mchakato wa kubanduliwa kwa naibu rais sehemu ya 5 inasema kwamba rais, hapa ikimaanisha naibu rais, atakuwa na haki ya kufika na kuwakilishwa mbele ya kamati maalum wakati wa kuchunguzwa. Kipengele hiki kikiwarusha wanasheria na maseneta pande mbili tofauti kuhusu iwapo Rigathi Gachagua ni lazima afike mbele ya Seneti ama anaweza kujadiliwa kupitia ripoti na ushahidi wake kisha apigiwe kura.
Sympathies and empathies.
Mwishowe,
give the Deputy President in the interest of justice, given the weight of removing a Deputy President from office, give him a couple of days.
It is your application to the Senate that your client be given a couple of days. Now, a couple of days doesn't mean much.
A couple of days I had in mind up to Tuesday. We should be able to know when the Deputy President is able to come and defend himself.
Lofty Matambo, NTV, Nairobi.
Assembly.
Mtazamaji, na hatimaye ni kama tulivyokujuzeni kwamba wameamua kila kitu kitaisha leo. Mtazamaji, awali baada ya Seneti kurejea katika vikao vya adhuhuri, wakili wa naibu rais Rigathi Gachagua alikuwa ameomba muda zaidi baada ya naibu rais Rigathi Gachagua kutopatikana bungeni. Mwite wakati huo alisema kwamba alikuwa ameelekea hospitalini kwa sababu hajihisi vizuri. Tumsikilize.
Your time started running at the time I requested you to usher in your witness. You indicated that you're getting hold of your witness. We'll give you all the time you need to get hold of your witness, but to let you know that the clock is running, and it's running on your client.
The Deputy President is not here, and by not being here, the inconvenience and delay caused to Mheshimiwa Speaker and to honorable senators. The position, Mheshimiwa Speaker, is that during that period that I went to try to find out why he wasn't here, because as Mheshimiwa Speaker knows, the Deputy President has been coming here absolutely punctually every day. The sad reality is that the Deputy President of the Republic of Kenya has been taken sick, very sick, and as I address Mr. Speaker in this honorable House, senators, he is in hospital, Mheshimiwa Speaker. That is a sad reality.
Mtazamaji, na sasa mtazamaji, moja kwa moja tuelekee katika majengo ya bunge ambapo wanahabari wetu Ibrahim Karanja na Duncan Haemba wanafuatilia mchakato mzima kabla maseneta kurudi kikaoni. Hebu tuwape nafasi watujuze kwa sasa hali mandhari yako namna gani katika Seneti. Haemba.
Lofty Ibrahim hapa, na ni kwamba bunge la Seneti kwa sasa tunavyozungumza, na kama ulivyowataarifu watazamaji, ni kwamba lipo katika hafla ya dakika 30, hafla ya faraga, maseneta pale wakizungumza kuhusu shughuli hii ambayo ipo mbele yao. Na sisi hapa kwa sasa, mwenzangu Duncan Haemba na mimi tupo nje ya majengo ya bunge tukitathmini hali ilivyo, kuanzia hali ya usalama hadi tutakapokuwa tukiingia ndani pia na kumwelezea mtazamaji ni kipi ambacho kilikuwa kikiendelea. Lakini Haemba, mtazamaji amekuwa akifuatilia, lakini pia atahitaji kufahamishwa kwa kina ni kipi haswa ambacho kilikuwa kikiendelea tangu tulipoingia mwendo wa saa 8:30. Akawa kwamba naibu rais Rigathi Gachagua hayupo kabisa. Wakili wake mwanzoni akasema kwamba ni mgonjwa, kisha baada ya mapumziko akaja na kusema kwamba amepata taarifa yupo hospitalini Karen, na ikawa tunashangaa iwapo ingeathiri mpangilio haswa wa vikao vya Seneti. Wewe umekuwa hapa bunge kwa miaka mingi iliyopita. Ni kipi ambacho unaweza kusema kwa kimombo wanasema kili stand out kutokana na vikao vya leo, haswa kuanzia alasiri?
Kwanza kabla tuangazie ambayo yamejiri, ambayo kidogo tutasema sijui ni sadfa ama ni ya kushangaza ama ni ya kushtua, lakini kabla hapo tu mtazamaji, ni kwamba kinachoendelea kwa sasa ni kanuni na taratibu za hapa bungeni. Kumbuka kwamba hapo jana kabla ya ngoma kuanza kutamba ama kutambarizwa, wanachama wa bunge la Senate kwanza waliingia katika kikao cha faraga. Taratibu zinasema hivyo, na baada ya mchakato wote, iwapo ni mechi tuseme baada ya dakika 90 kukamilika, sasa wanaingia kipindi ambacho ni sawia na cha kupiga penalty, ambako lazima waweze kujua kura zitaweza kupigwa kati ya mashtaka yote 11. Kwa hivyo kabla ya hapo pia taratibu na kanuni zinaeleza kwamba wawe pia na kikao cha faraga ili kuweza kulainisha mambo, kukubaliana je utaratibu utakuwa vipi. Ile tu kwamba pengine nakisia kwamba sijajua sana, sijai kwa mwanachama wa bunge, lakini nadhani pia labda swala la nidhamu pia speaker ataweza kuelezea kwamba leo ameweza kujizuia sana kuhakikisha kwamba asija akalaumiwa kwamba ameweza kumtoa spika yote ambaye amekiuka taratibu za mle ndani, seneta yote. Kwa hivyo nikidhani tu ni mambo ambayo wataweza kueleza kwamba tunaingia katika kipindi na ambacho ni cha kuamua mbivu na mbichi. Nidhamu iko ni ya hali ya juu, yoyote asikosee, aweze kuwekwa nje, isemekane kutupwa kwake nje ndio kulisababisha pengine kura ikaenda upande huu ama upande mwingine. Kwa hivyo ni hayo tu, lakini kwa haraka sana, manake tuna dakika za kuhesabu kabla turudi katika ukumbi wa wanahabari kujionea mambo yatakapokuwa nakamilika. Ni kwamba leo alasiri mambo yamekuwa kidogo ni ya kushtua kidogo, manake spika mwenyewe amesema kwamba naibu rais alikuwa mle bungeni hadi walipokuwa wanachukua mapumziko ya mankuli ya chakula cha mchana au chamcha, na akaweza kueleza kwamba watakaporudi ndiye atakaye fika pale kizimbani kutoa ushahidi wake ama kujietoa malilio yake kabla ya awamu nyingine ambayo ingefuata ya yeye pia kuja kusema mawili matatu ya mwisho kabla ya kauli kukatwa. Kwa hivyo ni mambo ambayo kidogo yameweza kushangaza, kila mtu akashangaza, lakini pengine katika ile hali ya kuonyeshana kwamba wana utu, waliweza kusema kwamba watachukua mapumziko hadi mwendo wa saa 11 ifike. Ilipofika wamerejea kwamba hajulikani aliko, kitu ambacho pengine kiongozi anayeongoza mawakili wake Paul Mwite aliweza pengine, na nilishindwa sana mbona hakuulizwa yeye kama wakili anayeongoza wale ambao wanamtetea, ikakuaje mteja wake au client wake aliondoka, yeye kusema hana ufahamu kabisa. Kwa hivyo unaona hapo kidogo, iwapo yeye mwenyewe anasema aliporejea alisema haezi kujua yuko wapi, he cannot locate his client, vipi naye ndiye anaongoza wale mawakili wake? Iwapo dharura iliwakumba walipoenda katika mankuli ya mchana, yeye ndiye angelikuwa mtu wa kwanza kuweza kufahamisha kuko vipi. Maswali mengine pia, leo naibu wa rais alikuwa ameandamana na wanawe. Umekuwa katika wale eneo la Nyeri, pengine katika wale watoto wake wawili kuna mmoja ambaye ni daktari, kuna mwingine si daktari. Pengine utueleze leo alikuwa ameandamana na nani, na kuhusiana na haya maswali kulikuwa vipi?
Na naibu rais alipofika, tuanze na jana aliandamana na mwanawe wa mmoja Kevin alipokuwa akija katika vikao hivi vya seneti, na leo hii amebadilisha akaja na daktari Keith Ekinu ambaye ni daktari. Kwa hiyo kuna huko kubadilishana kwa wanawe ni wawili, huko kubadilishana hatufahamu ni kwa nini, lakini ulichosema Kahaimba ni jambo ambalo lina uzito, kwamba iweje kwamba naibu rais Rigathi Gachagua akaondoka kutoka majengo ya bunge, ama iwe pia alikuwa afisini mwake akaondoka na kupelekwa hospitalini, ilhali mawakili wake ambao alikuwa nao kutoka shughuli hii ilipoanza jana, dakika baada ya dakika wasijue kwamba ameondoka, kiasi kwamba Paul Mwite anafika na kuieleza bunge kwamba I can't locate him kama ulivyosema. Kwa hiyo ni swali ambalo wengi watashangazwa sana.
Pia ni daktari,
mwanawe ni daktari.
Tangu jana hadi leo ikawaje hakuweza kutathmini hali ya kiafya? Maanake ni daktari
na daktari mwenyewe alikuja leo, maanake hakuwepo jana. Daktari alikuja leo hii, jana alikuwa amekuja na Kevin. Kwa hiyo ni maswali ambayo pengine tunahitaji kujibiwa, na pia wakati ambapo walifahamu kwamba afya yake haikuwa sawa, mbona haikuwasilishwa mara moja? Maanake kama tulivyosema mwanawe yuko hapa, ni jambo ambalo angejua haraka, lakini arifiwa kwamba spika wa seneti Amason Kingi na bunge limerejea. Kwa hiyo tutakuwa tukikurejesha mle ndani, na pia sisi tukielekea kule. Ni wakati sasa wa maseneta kujadili kisha kupiga kura kuhusu iwapo naibu rais Rigathi Gachagua ataendelea kuwa afisini au la.
Mr. Speaker, sir, I rise to move the following motion, which is a proposed removal from office by impeachment of His Excellency Rigathi Gachagua, EGH, the Deputy President of the Republic of Kenya. That aware that the National Assembly on the 8th of October 2024 resolved with support of 282 members, being at least 2/3 of all the members of the National Assembly, that pursuant to the provisions of Article 145(2), as read with Article 151(b) and 2 of the Constitution and the Standing Order 65(2) of the National Assembly Standing Orders, His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, be removed from office by impeachment on the grounds specified in the special motion. Whereas by letter referenced REF NA/DLP/TBO/MTS/2024 025, dated 8th of October 2024, and received in the office of the Speaker of the Senate on 9th of October 2024. The Speaker of the National Assembly informed the Speaker of the Senate of the approval of the special motion by National Assembly and further forwarded to the Speaker of the Senate documents in evidence of the proceedings of the National Assembly. Further, whereas pursuant to Article 145, as read with Article 151B and 2 of the Constitution and the Standing Order 78 and 79 of the Senate Standing Orders, the Senate had the National Assembly on the grounds for the proposed removal from office by impeachment of His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, and further whereas pursuant to Article 145, as read with Article 151B and 2 of the Constitution and the Standing Order 78 and 79 of the Senate Standing Orders, the Senate also had His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, on the grounds of his proposed removal from office by impeachment of the Deputy President of the Republic of Kenya. Now, therefore, pursuant to Article 145, as read with Article 151B and 2 of the Constitution and the Standing Order 78 and 79 of the Senate Standing Orders, the Senate resolves to remove from office by impeachment His Excellency Rigathi Gachagua, EGH, the Deputy President of the Republic of Kenya, on the following grounds. 1. Gross violation of Articles 10(2)A and B and C, Article 27(4), 73(1)A and 2B, 75(1)C and 129(2) of the Constitution, and Article 147(1) as read together with Article 131(2)C and D of the Constitution. Ground 2, gross violation of Articles 147(1) and 152(1) of the Constitution by undermining the President and the Cabinet and the effective discharge of the national government's executive mandate. Ground 3, gross violation of Article 6(2), 10(2)A, 174, 186, 189(1), and the fourth schedule to the Constitution by undermining devolution. 4, gross violation of Article 161 of the Constitution of the Constitution on the institutional and decisional independence of judges. Charge 5, gross violation of Articles 3(1) and 148(5) of the Constitution on the fidelity to the oath of the office and allegiance. Charge 6, serious reasons to believe that His Excellency the Deputy President has committed crimes under Section 13(1)A.
Give the majority leader the microphone.
So let me take that again. Charge 6, serious reasons to believe that His Excellency the Deputy President has committed crimes under Section 13(1)A and 62 of the National Cohesion and Integrity Act. Charge 7, serious reasons to believe that His Excellency the Deputy President has committed gross economic crimes under Section 45(1), 46, 47(3), and 48(1) of the Anti-Corruption and Economic Crimes Act, and Section 2, 3, 4, and 7 of the Proceeds of Crime and Anti-Money Laundering Act. Charge 8, serious reasons to believe that His Excellency the Deputy President has committed crimes by continuously misleading members of the public through false, malicious, divisive, and insightful remarks that are contrary to the provisions of Section 132 of the Penal Code and Section 29 of the Leadership and Integrity Act. Charge 9, gross misconduct that is incompatible with the high...
Make a mistake, you will make sure that when you are done, you have done, and you are sure that somebody is safe. Yeah. Yeah. Sorry, we kept you waiting because you are busy inside there, but I'm glad to meet you. Yeah.
So are we likely to see them coming out shortly? Now that they're in a stable condition,
No, I said I think we have to keep him at least for 10 to 72 hours to make sure that he is safe. Yeah. Yeah.
Doctor. Mheshimiwa Kadhani wa Mashwamba, Mheshimiwa, perhaps we can get your sentiments also, Mheshimiwa. Thank you very much. Nashukujeni hapa mbele. Please.
Mheshimiwa, thank you so much for speaking to us. You have been with the Deputy President. Perhaps what is his status at this time?
It's very unfortunate that the Deputy President is overwhelmed, and I guess that's why he's here, because he's completely crushed. We've not been able to have any conversation with him or even to see him properly, because we came in when the doctors were at it, and therefore we may not be able to talk about his medical status right now. But I'm sure you have heard from even the people who saw him come in. Things were a little bit heavy on him. Yeah, so we just came here to just support the family and support his workers, his support staff. They are really crushed, and we are hoping and praying that he's going to come out of it.
Mheshimiwa, we don't sit in the Senate, but you've just seen what has happened in the Senate. Maybe a sentiment on this as the Deputy President is still in this facility.
It's quite unfortunate that politics has pushed us to the extent that we no longer respect life or dignify life. Because I thought the honorable thing that...
Hedge, the Deputy President of the Republic of Kenya.
Senate Majority Leader.
Mic, please. My apologies, Mr. Speaker. I now hereby move the motion, which is a proposed removal from office by impeachment of His Excellency Rigathi Gachagua, EGH, the Deputy President of the Republic of Kenya. That aware that the National Assembly on the 8th of October 2024 resolved with the support of 282 members, being at least 2/3 of all the members of the National Assembly, that pursuant to the provisions of Article 145(2), as read with Article 151(b) and 2 of the Constitution and the Standing Order 65(2) of the National Assembly Standing Orders, His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, be removed from office by impeachment on the grounds specified in the special motion. Whereas by letter, reference NA/DLP/TBO/MTS 2024 into bracket 025, dated 8th of October 2024, and received in the office of the Speaker of the Senate on the 9th of October 2024, the Speaker of the National Assembly informed the Speaker of the Senate of the approval of the special motion by the National Assembly, and further forwarded to the Speaker of the Senate documents in evidence of the proceedings of the National Assembly. Further, whereas pursuant to Article 145, as read with Article 151 and 2 of the Constitution and the Standing Orders 78 and 79 of the Senate had the National Assembly on grounds for the proposed removal from office by impeachment of His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya. And further, whereas pursuant to Article 145, as read with Article 151(b) and 2 of the Constitution and Standing Order 78 and 79 of the Senate Standing Orders, the Senate also had His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, on the grounds of his proposed removal from office by impeachment of the Deputy President of the Republic of Kenya. Now, therefore, pursuant to Articles 145, as read with Article 151(b) and 2 of the Constitution and the Standing Orders 78 and 79 of the Senate Standing Orders, the Senate resolves to remove from office by impeachment His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, on the following grounds. 1. Gross violation of Articles 10(2)(a), (b), and (c), Article 27(4), 73(1)(a), and 2(b), Article 75(1)(c), and 129(2) of the Constitution, and Article 147(1), as read together with Article 131(2)(c) and (d) of the Constitution. Charge 2. Gross violations of Articles 147 and 152 of the Constitution by undermining the President and the Cabinet and effective discharge of the national government's executive mandates. Charge 3. Gross violations of Articles 6(2), 10(2)(a), and 174, 186(1), and 189(1), and the fourth schedule to the Constitution by undermining devolution. 4. Gross violations of Article 161 of the Constitution on the institutional and decisional independence of judges. 5. Gross violations of Articles 3(1) and 145(5)(a) of the Constitution on the fidelity to the oath of office and allegiance. Charge 6, serious reasons to believe that His Excellency the Deputy President has committed crimes under sections 13(1)(a) and 62 of the National Cohesion and Integration Act. Charge 7, serious reasons to believe that His Excellency the Deputy President has committed gross economic crimes under sections 45(1), 46, 47(a)(3), and 48(1) of the Anti-Corruption and Economic Crimes Act and sections 2, 3, 4, and 7 of the Proceeds of Crime and Anti-Money Laundering Act. Charge 8, serious reasons to believe that His Excellency the Deputy President has committed crimes by continuously misleading members of the public through false, malicious, divisive, and insightful remarks that are contrary to the provisions of Section 132 of the Penal Code and Section 29 of the Leadership and Integrity Act. Charge 9, gross misconduct that is incompatible with the calling and the dignified status of the office of the Deputy President and a member of the Cabinet and the National Security Council. His Excellency the Deputy President that has publicly attacked and undermined the work of the National Security Intelligence Services and its officers. Charge 10, gross misconduct by openly or publicly subordinating the President, who is the head of state and government. 11, gross misconduct by persistently bullying state and public officers. Mr. Speaker, I have observed that this is such a momentous task ahead, and I never imagined a few years ago, Mr. Speaker, that it will be possible after the journey that we have traveled with His Excellency the Deputy President in the political side that I belong to, that hardly 2 years down the line, I will have the difficult task of having to move the impeachment motion against him after listening to this case brought to this House by the National Assembly, in the case titled the National Assembly versus His Excellency Rigathi Gachagua. And the last 2 days, Mr. Speaker, together with other Kenyans, we have watched with lots of bewilderment, hard to believe pronouncements, and difficulty, Mr. Speaker, to believe that here is where we find ourselves as a nation. Despite the many challenges that we have gone through over the years, it was our hope, Mr. Speaker, that public officials would have picked up a lesson or two, especially those that are slightly older than yours truly, and many that are younger than me in this House, Mr. Speaker, and that in their conduct, they will reflect better the skills, demeanor, pronouncements of a leadership, Mr. Speaker, that this country continues to yearn for. Unfortunately, Mr. Speaker, listening to the case that has been brought to us by the National Assembly, I have reason to believe, beyond any doubt in my mind, Mr. Speaker, that they have justified the case that they have brought before us and have been able to ably demonstrate to us and to the country, Mr. Speaker, that there is no other cure by design of our Constitution to the challenges, either political or legal or otherwise, that are being faced, Mr. Speaker, by the workings and the working relationship between the President and his deputy, other than by way of impeachment. And the National Assembly has moved this House, Mr. Speaker, on 11 charges, blow by blow, with citations and examples in broad daylight, Mr. Speaker, showing and mapping, Mr. Speaker, that each charge, how it has been committed, Mr. Speaker, and how it violates either the Constitution or various laws of the Republic of Kenya. And therefore, Mr. Speaker, we are left with very minimal options. I have observed before this House, Mr. Speaker, that the Deputy President is personally known to me. I consider him a friend. I have had the opportunity to interact with him, learn a lot from him, Mr. Speaker, listen to his wise counsel sometimes. But this evening, Mr. Speaker, duty calls. And when duty calls, Mr. Speaker, there is very little that we can do. I am afraid, Mr. Speaker, that as legislators, as servants of the people, we have to listen to what the people are telling us. Mr. Speaker, we must appreciate that in 2010, when Kenyans went to the polls and brought about change via the new constitution, it was a call for us to have a better republic than had been observed previously since 1963. And there are various high ideals, high demands that have been placed in all of us that are in leadership. And I must add quickly, Mr. Speaker, that as you rise in stature from a member of a county assembly to a member of the National Assembly, senator, governor, deputy president, and eventually even as president, Mr. Speaker, that as you ascend in the hierarchy of leadership, the demands by the Constitution are even more. Number one, because you occupy greater public space, you represent more people. When you speak, Mr. Speaker, you say things that can affect either positively or otherwise the lives of millions of citizens. And therefore, Mr. Speaker, listening to the case that has been laid before us since yesterday by the lawyers of the National Assembly, reading through the bunch of documents that have been presented to us, attached with evidence, Mr. Speaker, I can confirm both to this House and to the country that unfortunately this country must make the difficult decision of having to say goodbye to His Excellency, the Deputy President Rigathi Gachagua, because, Mr. Speaker, the reasons that have been listed have consequences by law of what you do when this happens. The National Assembly has demonstrated before us, Mr. Speaker, that on charge 1, that there are various articles of the Constitution, either through his utterances or his actions, Mr. Speaker, that have led other Kenyans to seriously believe and feel lesser Kenyans, Mr. Speaker, something that we thought we had slayed. We thought that we had worked so hard to build a cohesive society where it didn't matter after a political contest, Mr. Speaker, of who eventually wins, that you'd feel comfortable, you'd feel safe, you'd want to do business in any of our 47 counties, Mr. Speaker, and feel at home. Unfortunately, Mr. Speaker, listening to the utterances, reading through the response, Mr. Speaker, and the pleadings by his lawyers, and the pleadings and the admission, Mr. Speaker, by his own affidavit, Mr. Speaker, that either my good friend, the Deputy President, doesn't appreciate the higher calling that the office he occupies demands of him, or he has completely refused, Mr. Speaker, to accept the dictates of our Constitution. And when you get to that law, that place, Mr. Speaker, where there is conflict between man and our Constitution, then man must give way for our Constitution to thrive. That is a demand of a public office. Mr. Speaker, I know this is not an easy exercise. I have agonized and sat there wondering whether there could be other ways we could resolve this issue. And I know for a fact that there have been attempts, Mr. Speaker, not just this time, but previously. I know for a fact, Mr. Speaker, that there have been occasions where either religious leaders, friends, people from business circles, Mr. Speaker, have attempted actually to mediate through some of these conflicts. But unfortunately, Mr. Speaker, instead of